Representative Long moves that House File 997 be laid over for possible inclusion in an omnibus bill. And Representative Long, you have a A1 amendment, is that correct?
Yes, thank you, Mr. Chair. So I'm move 997 as you suggested to be laid over for possible inclusion in the omnibus bill.
Is this the one that you took over?
Yeah.
And then I'll.
I'm sorry, it's a 0028 or A190028 amendment. Does that jive with your?
Yes, it is. And I would like to move the A19 amendment as well to have the bill in the form that I would like it before the committee. It's fairly straightforward. It strikes shall and inserts may. The original list of non-institutional sanctions that the Sentencing Guideline Commission can consider includes some dated concepts. The latest language hasn't been updated from 1978. For example, it includes a reference to day fines, which is not something that we are currently using. So this allows the commission the flexibility to reference them or not reference them as it chooses.
Very well. All in favor of the A190028 amendment, please say aye. Aye. Opposed, same sign. Motion prevails. Your bill is amended before us, Representative Long. And you have testifiers, I believe, as well.
I do. Thank you, Mr. Chair. Thank you for having me back for day 2 of probation week. And this bill deals with a related topic, but a separate approach to the bill we heard yesterday. Consistency is a fundamental principle of our justice system. It promotes transparency and accountability. It adds legitimacy to the court system. If you go back to 18th century Europe, reformers were pushing to establish consistent sentencing because they were challenging a system that was viewed by many as arbitrary and unfair. If you fast forward a couple centuries to 1970s Minnesota, reformers were raising similar concerns. And in 1978, Minnesota created the nation's first Sentencing Guidelines Commission. Then in 1980, Minnesota became the first state to implement a sentencing guideline structure. To put that in context, that was the year before I was born. So Minnesota has a lot to be proud of, and in no small part due to this legacy of being a first mover. But as we discussed in detail yesterday, there's a glaring hole of unfairness in our state system when it comes to probation. Our committee heard testimony about the regional disparities we face in our probation system. In some parts of Minnesota, the average probation length is 3 years, while in others it is 7 years. We are failing the basic test that those convicted of the same crime should receive similar punishment. For this reason alone, we need to standardize our probation system. We also still have extreme probation sentences like the 40 years that Jennifer Schroeder testified in front of our committee about that she received for her nonviolent drug sentence. We are currently only providing guidance to courts on a portion of the punishment that we are delivering as a state, and I believe it is time to ask a trusted Minnesota institution, the Sentencing Guidelines Commission, to put its resources and collective wisdom towards tackling the challenge of probation. The bill before us would require the commission to establish guidelines for probation. Discretion would be left to the commission to consider offense and offender characteristics as it does with incarceration. To be clear, the commission currently has this authority to establish appropriate guidelines for probation, but it's had 41 years and hasn't taken action yet. As Director Mitchell mentioned, other states with a grid for sentencing also have incorporated probation, such as Kansas and Oregon. And I believe a nudge from this committee and the legislature is appropriate, given our current understanding of the challenges the state is facing in this area. The bill would also expand the Commission's data collection responsibilities to include specific probation data. These are probation terms, recidivism, revocations, and conditions of probation. And I've heard consistently from all stakeholders who are involved in probation that there's a real need for more data, and this will assist with its collection. I view this bill as complementary to the 5-year probation cap we heard yesterday. We have in the past given the Commission guidance about maximum sentences, but also allowed them to establish recommendations within those maximums for the sake of consistency. And I believe in the probation context, this would work well for this pairing. And unless there are questions for me, I'm happy to move forward to bring the presenters.
Why don't we do that?
Okay. First will be Commissioner Schnell.
Welcome back to the committee, Commissioner Snell.
Thank you, Mr. Chair and committee members. I first of all want to say thank you to Representative Long and all the members of the committee for bringing some attention to this issue. I'm in a little bit of an unusual position here because I wear two hats. One as the Commissioner of Correction and one as simply one member of the Sentencing Guidelines Commission. So I want to be really clear about the fact that I do not speak for the body of the Sentencing Guidelines Commission. That said, as Commissioner of Corrections and certainly as an individual member of Sentencing Guidelines, I am concerned about issues of disparity and fairness around probation terms. I think that should be a fundamental fairness and justice question for all of us. Ultimately, it shouldn't be based upon which county you live in when you are being sentenced for these crimes. And we can simply look at the distinction between this county and the county to the west. And looking at terms of being 38 months, we look at all offenses for probation terms in Hennepin County versus 67 in this particular county. And I think as a body, as a community, I think as Representative Long talked about, it is incumbent upon us to make sure that there is fundamental fairness around this and that these probation terms link with what evidence tells us about what works and what doesn't. And that ultimately, we really focus most heavily on defining and being clear about what works, what's effective in terms of probation terms, and how it is that we assist people to do well while they're on probation to become fully active and pro-social members of our community. So I would stand for any questions, but certainly we stand behind and I think want to recognize the fact that fairness becomes a fundamental and core issue around my personal support of this and my role as a sentencing guidelines commissioner, of having the commission look at this at the same time on the broader level. As the Commissioner of Corrections, I think it is important and critical that we address this fairness issue across the board. Thank you.
Thank you, Commissioner Schnell. I think you made your values quite clear here, and obviously, knowing you, they're rooted in many years of experience. You heard Representative Long earlier state that he thought that the commission does have the ability under law to create guidelines for probation. Do you share that thought as well?
Mr. Chair, committee members, I will tell you that I'm not a lawyer, and that's probably a good thing.
I agree.
But I think just broadly reading the language, it appears that way. Again, I defer to people who I think have a whole lot more of the background, but based on the language as I've read from a plain language standpoint, it does appear that the Guidelines Commission does have some ability to explore and look at this issue.
Thank you. And as I claimed for you earlier, I thought you expressed, in addition to that, your own sense of values in terms of it ought to have that authority as well. Are there any questions for the commission? If not, then thank you, Commissioner.
Thank you. Thank you. I appreciate it.
Representative Long.
I'm going to call up my next two presenters, Ben Feist with ACLU and Lars Negstad with Isaiah.
Very well. Please come forward.
And for the committee's knowledge, there's two following this, so we won't have quite as many as yesterday.
It's all about quality, Representative Long, not quantity.
Well, they're all quality.
Yes. No argument here.
Mr. Chair, members of the committee, my name is Ben Feist. I'm the Legislative Director of the ACLU of Minnesota.
Welcome to the committee, Mr. Feist.
Thank you, Mr. Chair. And yeah, for those who are not familiar with the ACLU, we are a nonpartisan, nonprofit organization dedicated to protecting the civil liberties of all Minnesotans under the U.S. and federal constitutions. And we do this work through lobbying, through litigation, and community engagement. We currently have over 40,000 members throughout the state of Minnesota. So I'm testifying today in support of House File 997. We did not have the opportunity to testify yesterday regarding our strong support of the 5-year probation cap in House File 689, but I did want to put that on the record as well. We think that's a great idea. Probation is a key contributor to mass incarceration. Through widening the net of people in criminal justice, in the criminal justice system, keeping individuals under correctional control for lengthy periods of time, and the overutilization of probation revocations. The amount of time that a person spends on probation should be limited to the time needed to achieve rehabilitation, accountability, and public safety. As we've already heard, our current probation system in sentencing practices results in disparities based on geographic location rather than an individual's risk and needs. The Sentencing Guidelines Commission can and should have a role in addressing issues in our probation system. In particular, the Commission is well suited to look into the issues of the regional and racial disparities in probation rates, as it does effectively with other sentencing issues. In order to address over-incarceration in Minnesota, we need to better understand the role of probation sentences and revocations. This bill simply emphasizes that the Guidelines Commission has the appropriate expertise and mission to delve further into this important topic. To be clear, this bill is not a substitute for legislative action on the needed 5-year probation cap, but it will encourage the Commission to dive deeper into the role of probation in our criminal justice system, and we certainly believe that is much needed right now. With that, I'm happy to answer any questions.
Thank you, Mr. Feist. Why don't we hear from Mr. Nextad as well, and then we'll open it up for questions.
Thank you, Mr. Chair and members of the committee. My name is Lars Negsted. I'm the policy director for Isaiah. Isaiah is a statewide organization of people of faith working for racial and economic justice. I come today not as an expert in criminal justice or as certainly not as a lawyer, but to speak out of our values of mercy and redemption, and that we all fall short at some point, and no one should forever be judged by their worst act. We believe we are all spiritually diminished when we succumb to punitive instincts rather than strive for redemption and reconciliation. I'd like to also support the bill that came forward yesterday, which we did not testify on, but we support the notion of a cap. Some of the discussion this week about probation has pointed out that Minnesota is indeed better than many other states when it comes to incarceration rates. But I'd like to note that when you compare our incarceration rates to the rest of the world, we are actually quite a bit of an outlier. Canada has a lower incarceration rate, as do about 150 other countries, including countries on every continent. So we're already an outlier on incarceration. We're a further outlier, as we've heard, on probation. And we appreciate this committee's attention to this issue and Representative Long's bill. From the summary from House Research on House File 997, there is a sentence, the enacting statute stated that a primary goal of the sentencing guidelines is to maintain uniformity, proportionality, rationality, and predictability in sentencing. Yet from the presentation of Ms. Mitchell earlier in front of this committee, you can see that the average probation sentence in the 2nd district, which is Ramsey County, is nearly 6 years, while the average probation sentence in the 4th judicial district, which is Hennepin County, is about 3 years. So that's a pretty jarring distinction, and it's hard to read those statistics for the average person because it's the 2nd district and the 4th district, and it's in months, but just that 3 years versus 6 years, depending on which side of the river you live on, seems irrational and far from uniform. I did follow some of the ECC work group, the Earned Compliance Credit Work Group that was convened and mentioned in yesterday's hearing. And one phrase stuck with me from that. A probation officer said that even a good probation officer runs out of things to say after about 5 or 10 years. The other note that I'm sorry I haven't been able to find the source and the data on this, but I believe workload and caseloads on probation officers has dramatically increased over the last 10 or 20 years. And so the amount of attention that probation officers can give to each client has diminished because of that. So that's something that I would encourage you to look at. My experience from observing the Minnesota Sentencing Guidelines Commission is they've taken some laudable steps in the right direction. It feels like it's taken an enormous amount of advocacy and cajoling to get them to do that. We think that this bill is a good push in the right direction for them to add probation into the sentencing grid. Thank you for your attention.
Thank you, Mr. Nexted. I am struck by both of your affiliations with your organizations that there are energies that are focused on civil rights that have concerns about the state of our probation terms in our state, and that there are faith communities that also share those concerns. I'm particularly struck, Mr. Nexted, you know, I'm new to chairing this committee, and so I'm on a rapid learning curve. One of the things I've learned, I guess I knew about it, but I'm struck by the deep involvement of a diversity of faith communities working with people in our corrections system. Whole communities have insisted on not giving up on their fellow citizens, and who are coming forward in the way you're coming forward and representing Isaiah to express the desire for a policy change relative to this issue. It says something, I think, mighty strong about good values in the state of Minnesota. Representative Law, oh, actually, are there any questions for our testifiers? If not, thank you, gentlemen. Representative Law.
I'd like to invite up my last two presenters, Dr. Raj with the NAACP and Gina Evans with the Teen Challenge and Second Chance Coalition.
Welcome to the committee, Dr. Raj, and Ms. Evans, I look forward to your testimony.
Thank you. I have no idea what the formal greeting is. Hi, everybody.
That works.
How's everybody doing? Okay, good. Thank you for the opportunity to speak in front of you. I've got just a few points just to remind us the history of the sentencing guidelines starts in 1978, but we
Dr.
also...
Raj, I apologize. We need to do this. We have to have every testifier state their name for the record.
Okay.
Because we take these and we...
Oh, say my name, Raj. Last name is Sid Raju. Is that cool? Okay.
That works. Thank you,
Okay.
Dr. Raj. I apologize for the interruption.
No, I'm sorry. I'm not too formal here, so I apologize. Thank you all for accepting my informalities here. As I said, when we think about the sentencing guidelines, we have to realize that in 1970, those who were incarcerated at large in the United States of America were about 300,000 people, right? And you look in 2010, 2011, you have about 2.1 million people incapacitated in our system. And as a result of the pronounced need to control the population, and especially those who are disenfranchised, communities of color were disenfranchised and were trapped in our system in the name of public safety. And that led to us, Minnesota, right, the liberal, nice, wonderful Minnesota, to figure out what are we doing, because we have a five-fold increase in our sentencing since 1978. And in 1978, we passed this particular sentencing guideline commission that examined, and their charge was to, proportional, figure out proportional offenses culpability and the crime and eliminate disparities, be rational and consistent, right? Treat prison beds as a scarce resource, not as a economic benefit. And yet we know that is what has happened. It is no longer a scarce resource. Our prison beds, they have become a way of intensifying job opportunities in our communities. So we have turned this tide into an economic opportunity. I'm hopeful that the sentencing guideline, as was the grid, as was put out there, gives us a sense of who is trapped in the system. And if we are spending $35,000 a year, right, to maintain one individual in our system, then how would that $35,000, if invested back in our community, what would that produce? For every dollar that is spent inside our prison system, what would that translate in our community? So I want to invite us to think about the ways that we can manage this particular spending that we have started, and in the name of sentencing people, incapacitating people in our system, and allowing them to thrive in our community, finding ways to address this particular sentencing guideline grid, right, that has been put together and now being practiced or invited to be practiced by our judges in our court systems. And then also understanding that much of this grid is also pushed or sometimes compensated or sometimes compromised as a result of the power of the county attorneys, right? So this particular bill doesn't address how county attorneys impose themselves on making sure that certain crimes get certain amount of punishment and others have an opportunity to walk out of the system and fight the system. So I want to kind of invite us to think about those things, right? And also the other component that I want to stress on is this concept and construct that in criminology that we are talking about, incarceration, right? Sentencing guidelines now has led to more and more people walking around with monitors on their ankles and all places. And these are starting with 10-year-olds and 12-year-old kids all the way to adults. And this has become spun an industry, an entire industry that is living off incarceration, right? Electronic monitoring has become a reality. And one other point just to really stress is this is what in criminology we call not mass incarceration, but mass forms of punishment. And Michelle Alexander pointed out when she was here to speak, because initially when she was invited, she said, why would I go to Minnesota, the most progressive state? But then when she dug down into some of the data of people who are on our probation and parole, then she realized that there is such disproportionality and the immense weight of probation, right, has been disproportionately distributed to communities of color, right, especially African American and Native American communities. And so we want to kind of ask you to think about how sentencing guideline needs to be couched in a way that also addresses the needs of our community as not just simply the weight of, okay, let's be nice, let's do five years top probation, and then let's also address sentencing guidelines according to the kinds of the crimes that has been listed here, not based on the needs of our community, right? So I want to invite us to think and humanize the process as opposed to dehumanize and remove ourselves and just simply live based on the grid, right? Appreciate it. Thank you.
Thank you, Dr. Raj. So yesterday, I believe you were here yesterday, we heard about concerns around disparities. They were primarily framed in terms of regional characteristics. And I believe Mr. Godfrey shared that with drug offenses across the board, cumulatively, we have a state where there's an 82-month difference in terms of an average probationary term for those offenses. It took me by surprise that in one state we would have that kind of regional disparity. I think what I hear you saying, adding to that today, is that there are other disparities here. And so I'm wondering if perhaps you can expound a little bit about that.
In terms of disparities, right, so the way offenses are managed and sentencing disparities exist, but it is also weighted towards communities of color, right? Communities of color disproportionately get more punishment and more times of stay within our prison systems or within the probation and parole systems that we have set up in the name of public safety. So when you say disproportionality exists, it exists also in the context of who is our children who are being suspended, right? Largely our children who are suspended are children of color, right? And you also have children who are taken out and classified as level 4 schools. They are now put in level 4 schools as opposed to level 1 or level 2, whatever those lower levels schools. So disproportionality exists in schools and the way our children are classified, and then disproportionality exists in terms of who is weighted down by probation and parole and by monitors that monitor every one of their moves. And if you don't report, don't pay your fines or get to the probation office at a certain time, all of these things disproportionately affects communities of color who have less access to resources that is needed. So if your probation office is set up in Minnetonka and you have to come from North Minneapolis, right, just the sheer travel business is overwhelming. And you have to take an entire day off to counter and to be responsible for your action, right? So you are now losing out on the income of the day. So in that context, there are lots of disparities that exist. And then just to belabor this point, communities of color have more, are used as an example of public safety and how well we are doing in public safety in this country by just simply saying that we have more people of color on electronic monitoring. Right, that also exists within our, and yes, Hennepin County may have a lower level of charge, but let's not forget there are a lot more people of color who are in probation in Hennepin County, and they are and weighted down by warrants, also, right? And the warrant forgiveness day that NAACP and ACLU do, Hennepin County refuses to participate in community-wide warrant forgiveness day, because they are afraid that people will take advantage of just coming to those community-wide warrant forgiveness day as opposed to going to the courts, right? They have 11,000 outstanding warrants a year in Hennepin County, about 8,000 to 9,000 outstanding warrants in Ramsey County, about 8,000 in Dakota County. But those are, and they are weighted, that weighs communities of color down too. So that's another disproportionality in terms of who has warrants and who doesn't.
Thank you, Dr. Raj. I do appreciate the call for to humanize the process and to ask the question what the needs of our communities are relative to this. I'm going to turn it over to your colleague now, Ms. Evans. State your name for the record and please give us your testimony.
Thank you, Mr. Chair and members of the committee. My name is Gina Evans, and I serve as the Director of Outreach for Minnesota Adult and Teen Challenge, as well as the Vice President for the Minnesota Second Chance Coalition. Mr. Chair, if you're interested in the actual data, the Sentencing Guideline Commission put together a report in 2016 when we worked on the sentencing guideline drug reforms. I know they pulled that data, and that was one of the charts that was part of that report if you wanted to see the actual disparity by race.
Thank you,
that data is available.
Thank you, Ms. Evans. I'll have my staff pull that up and share it out with committee members as well. Thank you.
Yep. So, you know, it's really sad for me to say, and I think back on it now, and if it wasn't as important as it is for me to talk about it, I would be ashamed of it. But the conversation that you guys are having about probation reform and caps, I think I speak to the other side of that. I've been convicted of 13 felony convictions. All of them but one were presumptive probation according to the sentencing guideline. I went to prison on all of them. I could not get through probation, and that happened really quickly. Within 12 to 18 months, I had violated my probation enough times that they revoked my suspended sentence and sent me to prison. It happened really quickly because I made a decision not to stop using drugs, not always because I committed additional crimes, but because I wouldn't stop using drugs and alcohol. From the time that I was 19 years old until I was 32 years old, I never successfully completed probation for 13 criminal convictions. I got out of prison the last time in 2003 and entered into Minnesota Adult and Teen Challenge. And having a year in prison and a year at Teen Challenge really helped to heal my brain and helped me to really start to believe that I deserve something different and that my life could be different. I've been to prison 3 different times, and I'll talk a little bit more about that when I testify on the alternatives to incarceration bill. The thing that I just want to encourage you guys to do is to really look at what's fair and what eliminates the disparities that we see regionally and in communities of color. My husband was given 40 years of probation on a conspiracy to manufacture methamphetamines charge in Hennepin County. He is Caucasian and educated and really worked hard to come out from underneath that. After 4.5 years of probation in Hennepin County, he was released from probation 36 and a half years early. I have another friend, Mark, who got a 4th DWI in a county that we've talked about a few times over the last 2 days, and he ended up having to do 6 of those 10 years for a DWI. You guys heard from Jen yesterday, it'll be 20 years before she's even eligible in Wright County to get an early discharge from probation. So the disparities in probation lengths and policies from county to county makes for not a very just or fair system. As a director at Minnesota Adult and Teen Challenge, I work a lot in the criminal justice system with county attorneys, with probation officers, with parole agents, and public defenders. You may think that what Jen talked about, 40 years of probation, or my husband, 40 years of probation, is the exception to the rule, and I'm here to tell you that it's not. We at Teen Challenge are considered a diversion from incarceration in the criminal justice system, and we see 20, 30, and 40 years of probation regularly, weekly, for the clients that come through our program. And I just really want to encourage you, I want to plead with you to really consider offering shorter probation sentences. That could mean that our probation officers would supervise fewer individuals, and then we could focus our limited financial and manpower resources and time and attention on the inmates, our returning citizens that need that extra time and attention to ensure that our communities are protected and that our returning citizens achieve success. So.
Thank you, Ms. Evans. Representative Long. Well, actually, are there any questions for these testifiers? All right, Representative Long.
Thank you, Mr. Chair. That completes my presentation.
Very well. Are there any questions for the author of the bill? Representative Moeller.
Thank you, Mr. Chair and Representative Long. This might be more for House research if you don't know the answer, but I had a question about page 2, lines 2.3 to 2.5 that says that this doesn't prevent the court from imposing a sentence for a felony conviction within the limits provided for misdemeanor or gross misdemeanor. Would those, if it's a felony conviction and the court's sentencing to a misdemeanor or gross misdemeanor, under the way the law operates now, it's considered a downward durational departure, and the court has to find factors to make that happen. And I just wanted to clarify that the court would still need to find those factors in order to decrease that sentence.
Representative Long, it would be good to have that on the record.
Thank you, Mr. Chair. Representative Moeller, thanks for the question. That's the intent. The intent was to make clear that we're not changing the ability to allow courts to give sentences that are consistent with misdemeanor, gross misdemeanors for felony convictions. It's not intended to change the current operation of downward departures.
Thank you. That helps. Thank you.
Thank you. Are there any further questions? Representative O'Neill.
Thank you, Mr. Chair. I have a technical kind of question, too. So it says that any other state agency can be required to integrate the data with the Sentencing Guideline Commission. So which other agencies are you envisioning to be a part of that?
And Representative O'Neill, what page reference is that? Oh, I'm sorry, I thought you were reading off of the bill. Oh, you are.
I am, but let's see here.
Mr. Chair.
Why don't we ask our House Research to help us here? Mr. Johnson.
Mr. Chair, members, I believe she's referring to Section 3 and specifically the new language at page 3, line 11 of the bill.
Thank you. And perhaps Ms. Mitchell might be able to help as well. Representative Long, but please.
Thank you, Mr. Chair. Thank you for the question, Representative O'Neill. So the goal here, I think, is just for some of the data that may need to be collected, giving them the flexibility to work with other agencies. I don't have a particular agency in mind. It may be that Director Mitchell might have one.
Ms. Mitchell.
Mr. Chair, Representative O'Neill, thank you. The Commission currently has a data integration with the judicial branch, and most of the data half of the data that they receive comes from the judicial branch. That's the sentencing information that comes in. Then they also have the statewide sentencing worksheet data, and that's what the probation officers enter. Combined together, that's their current database. If they were to expand to get some more of this data, the things that I would imagine that they might have to do would be to get more data from the courts, what happens after sentencing. The statewide supervision system, which is housed at DOC, contains revocation reasons for probation. And then the Bureau of Criminal Apprehension has recidivism, the criminal history information. So I'm not saying that's what would happen, but those are possibilities that I'm aware of that they might need to go to.
Thank you, that helps.
Thank you. Very good question, Representative O'Neill. Thank you. Any further questions? Representative Johnson. Oh, I'm sorry. I jumped over. I'll get back to you. Representative Edelson and then Representative Johnson.
Thank you, Chair. Representative Long, I just wanted to thank you for bringing up these bills from yesterday and today. I was honestly shocked to learn about some of the disparities. I think many of us from the public or people that are not as familiar with probation guidelines, that we don't have them. And so I thank you for your advocacy in this area. I'm a strong supporter.
Thank you, Representative Edelson. Representative Johnson.
I want to give, Mr. Chair, I want to give Representative O'Neill a heads up. When I read this bill earlier, I did not catch that. I think there's going to be quite a bit of cost to putting those programs together. I was just wondering if fiscal note had been requested.
Okay. All right. So that's. Oh, I didn't realize it was here. All right, let's deal, I'm sorry, we're trying to get my act together here. I don't believe a fiscal note has been asked, but perhaps our fiscal analyst can share some information now.
Mr. Chair, it looks like line 3.11 could have some costs. I don't recall whether or not I put in a fiscal note request on this bill.
And we'll certainly have time to be able to vet that. Representative Long.
Mr. Chair, Representative Johnson, I had not put in a fiscal note request. One of the reasons was I know the Sentencing Guidelines Commission is still putting together their budget request and was going to see if there may be a request in their budget for some additional help for programming like this. But that, I think, would be a fair thing to find out.
And we're certain, and our intent is to lay this bill over so we'll have time to be able to pursue that further. Any other questions? If not, Representative Long, I want to thank you. I want to thank your testifiers. and for the conversation as well. And so the chair will now lay over House File 997 as amended for possible inclusion in the omnibus bill.